The statute should be read as a whole or construction. Ex visceribus actus. One of the important general principle of interpretation is that the statute should be read as a whole and all parts of it taken together while construing a provision. This principle is also stated as that a statute is to be interpreted ex visceribus actus, that is, no say within four corners of the act. A provision cannot be interpreted in isolation. Sometimes the meaning of words may be determined by other words used in the same section, while in some cases a section may be interpreted in the light of some other sections in the same statute. The idea is to make a consistent enactment of the whole statute, and for this, the context and other provisions of the Act are important considerations. The court should, however, be careful not to carry too far a construction of a provision with the help of other provisions, and should do so only when it feels that the legislature must have so intended. A doubt in the mind of the court that the legislature might not have so intended should be enough same section ground for it to hold that the legislator did not so intend. Similarly, a word used in the same section more than once will have the same meaning. Normally, there may sometimes be compelling reasons for not interpreting a particular section in the light of another section. In all cases, the scheme of the act as a whole should be the guiding factor. Nothing is better settled than that a statute is to be expounded, not according to the letter, but according to the meaning and the spirit of it. What is within the true meaning and the spirit of the statute is as much law as what is within the very letter of it, and that which is not within the meaning and the spirit, though it seems to be within the letter, is not the law and is not the statute. The effect should be given to the object, spirit, and meaning of a statute is a rule of legal construction. But the object, spirit, and meaning must be collected from the words used in the statute. It must be such an intention as the legislature has used fit words to express. This rule should not be used when the meaning of a provision is clear. The rule applies to interpret only obscurely penned statutes. No particular phrase of a statute is to be interpreted detached from its context. The whole context should be reviewed. The intention of the legislature gatherable from any other part of an act must be considered during construing a provision of the act. Use of the words like if not consistent with the context or subject matter, unless the context otherwise requires, and unless a contrary intention appears in acts are indications of application of this principle.